Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest. Your Honor, I'd like to address a Rule 20 motion first.
Go ahead.
Okay. The state has failed to show substantial evidence for count 1, conspiracy to commit first-degree premeditated murder. The state has provided no evidence that I agreed with another person that any one of us would engage in certain conduct that I intended to promote or assist in this premeditated murder. Crime premeditated murder requires the state to establish a person caused the death of another with premeditation. The lack of evidence to show any evidence of a conspiracy to commit murder, there was no plan to murder Charles. No evidence has showed that, in fact, evidence suggested self-defense on the part of Alex. So I would like to put that on the record.
All right. State, want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon everything from the iCloud messages from between Alex, the defendant, and others leading up to July 11th of 2019, that Alex Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles Vallow and the fact that the number of shots and the physical evidence at the scene, the statements by the defendant to Detective N-Clan that she took Charles Vallow's phone and would not give it back to him, the motive for money, and especially the defendant's motive for having an affair with Chad Daybell, all of those looking at together in the light most favorable to the state, the defendant, or the jury could find the defendant guilty of conspiracy to commit first-degree murder.
Last word. Do you want to add anything?
No, Your Honor.
All right. The standard is whether or not a reasonable juror could, whether or not there's substantial evidence for a reasonable juror to find the defendant guilty. The court does find that there is substantial evidence that a reasonable juror could find the defendant guilty. The court will further add that the jurors are the ones who judge the credibility of the witnesses, and it's ordered denying the Rule 20 motion. Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest.